Morning, class, my AP students. I've got my coffee ready, and I'm going to begin one of my first lectures with you right now. Today's lecture is on the introduction to the judicial branch or the federal judiciary. So I'm going to put on the screen right now. I'm going to share with you on my screen this presentation. So we're going to go through this and look at the federal judiciary as you begin Unit 2C. So one of the things to know about the federal judiciary is that it is both adversarial and passive. And what we mean by that is that it's passive in the sense that the courts don't go out and try to find criminals, and the courts don't try to go out and find people that are arguing with each other. The courts wait for cases to come to them. That's what's meant by that they're passive. It's an adversarial system in that when people come to court, they do so in competition with each other. And it is there that we hope to find justice. So in a criminal case, which we call in a criminal case, it's the prosecution who brings the case against an individual or a group of people, and we call those people that are being prosecuted defendants. And then we have civil cases in which one party is suing another party, either for a result or for damages. And in that case, the party who brings the suit against another party is called a plaintiff, and then the one who has to defend themselves from the suit is called the defendant. So when we look at court cases, there are two types of courts that hear cases. There's courts of original jurisdiction and courts of appellate jurisdiction. And what do we mean by this? We mean that the case where the facts are heard, in a criminal case where they determine guilt or innocence, that is the case, the place of original jurisdiction. And it is there that the facts are heard in a case. In a civil case, they have civil cases of original jurisdiction as well. Then we have these other courts that review courts of original jurisdiction, in which we call appellate courts. And in these appellate courts, they hear whether or not the law was followed correctly at the trial. They do not hear issues of fact, guilt or innocence, but they determine if people's rights were being followed while the court procedures were being conducted. And so if you look at a diagram of our structure of our court system, we have our federal courts, and down below you have your courts of original jurisdiction. And in our state courts, we have our state courts of original jurisdiction. And so if an individual kills their spouse, they will most likely go to a state trial court for a criminal court. Or if you don't like how you've been treated by another person in your business practices and you want to sue them, most likely it's going to take place in a state trial court. But let's say if an individual kidnaps somebody and they went across state lines, it's possible it would be done in a federal court of original jurisdiction, in a district federal court. But most likely the federal FBI would send the individual back to a state trial court to be heard. And so both court systems, the state court system and the federal court system, have an appeals court level, a circuit court, that can hear the appeals of the courts of original jurisdiction. And states have supreme courts as well to hear matters of their state law was followed accurately. Here in the state of Florida, if you receive the death penalty, you are guaranteed a hearing before the Florida Supreme Court to determine whether or not that death penalty was just. And we often call the United States Supreme Court the court of last resort, because it is there that we could determine the constitutionality of any law and set precedent for future decisions that are made in other cases. And so a case that happens at the state Supreme Court can actually go to the United States Supreme Court. So the United States Supreme Court is looking for the appeals process to be exhausted before it hears a case, and is looking for the state appeals process to be exhausted before it hears a case. So one of the main functions of the Supreme Court and appellate courts is judicial review, and it's the right of the courts to determine not only if a law was being properly done while the trial was being conducted, but also to determine the constitutionality of a congressional law or the actions of the executive branch of government. It is their most important check they have over the other branches of government. So the federal courts, the founders were expecting judicial review. Soon you're going to be reading about Federalist 78, and it's going to discuss some of the ideas that Hamilton had regarding judicial review. The traditional view is that judges only apply law, and that they also are passive, kind of like a umpire is supposed to just call balls and strikes. But over time, especially in the 20th century, that began to change, and the courts became more active. The development of the federal courts began with the case of Marbury versus Madison. You're going to be looking at that court case in particular later on in the unit. And that is where it was determined that judicial review was constitutional, and that the Supreme Court can declare an act constitutional or unconstitutional. The court case of McCulloch versus Maryland that we went over in Unit 1 about the national bank set up supremacy of national law, as well as how the Constitution can be interpreted broadly through the necessary and proper clause. So the Supreme Court is really the only court in the diagram we previously looked at that is mentioned in the United States Constitution in Article 3. And the power to create a court system is granted to the legislative branch, to our Congress. And so one of the first orders of business, in addition to passing a Bill of Rights, was to pass the Judiciary Act, which outlined the district court system, the courts of original jurisdiction, and set up the process of how appeals would work and how the Supreme Court would hear cases. And it set up 6 justices. Today we have 9 justices. There is no particular number that's constitutional in terms of the justices. It's only customary. You probably remember when in the 1930s when Franklin Delano Roosevelt tried to pack the court, but Congress at any time could decide that the Supreme Court should be 7 justices or 11 justices, or even an even number of justices. So the district courts, there are 94 district courts across the United States of America. Every state has at least one. They include criminal courts, and include civil courts as well. They hear more than 300,000 cases a year, and like most cases, both state and federal, these cases that happen in the federal court, usually when they're criminal, result in a plea bargain before they get into court, meaning the two sides get together and they come to an agreement that is beneficial to both parties. Usually the prosecution is offering a lower sentence or a reduced charge to the individual, the defendant, and the defendant is getting in return less time in jail and the ability to go home sooner and live his life of freedom. In civil cases, they usually result in a settlement before they actually go to court, where the two parties, the party who is suing the other party, the plaintiff who's suing the defendant, will come to an agreement before the actual trial. See, only 2% of cases go to trial. In criminal cases, again, they're plea bargained out. In civil cases, they are settled. This map here shows you the federal court system, in which you see 11 courts of appeal. Our court of appeal system, like if you have a trial in federal court, you can appeal your decision to Atlanta, Georgia, to the 11th Circuit Court of Appeals. You would do that if it's a federal court case. If it's a state court case, the federal appeals court don't get involved. It will go directly to the Supreme Court of the United States as the court of last resort. So you can see that Alabama, Georgia, and Florida, all the 40 some odd courts that are in this region are under the 11th Circuit Court of Appeals purview. And so why does the Supreme Court hear a case? It's usually because one circuit court of appeal has made a decision that is quite different than another circuit court of appeal. For instance, the 11th is much more conservative than the 9th Circuit Court of Appeal, which is very liberal. And so the 9th Circuit Court of Appeal may come to a different conclusion than the 11th Circuit Court of Appeal on similar cases. As a result, the Supreme Court, because of the full faith and credit clause, feels itself compelled to hear and settle this difference in how the Constitution is interpreted. Here we have the decision on the Supreme Court the notes on the Supreme Court being the court of last resort. I think this little cartoon is kind of interesting, talking about diversity on the court. We do have a diversity on the court. We have one African American, one Hispanic. We have 4 Jews. We have 5 Catholics on the court. And so there is a great deal of diversity, I guess, than in years past. But one thing that's not very diverse, if you look at the court, they all went to Harvard or Yale. So that's an interesting fact about where to go to college if you want to be a Supreme Court justice. That's been the case in the last 40 years, that every new justice appointed to the court has come from Harvard or Yale. This is a description of the different types of federal courts. I mentioned that there are district courts that hear civil cases and criminal cases, but there are other types of courts as well. There is claims against the federal court. There are veterans courts. There are international trade courts. There are tax courts. And this diagram here shows that they all go to courts of appeals. There are appeals courts that handle just veterans claims and federal claims, and there are appeals courts that hear just tax and international law as well. So that is why there are 2 additional appeals courts that you didn't see on the diagram from before. And then we have over here another type of federal court, which is called the Uniform Code of Military Justice. That means if you're in the armed forces, there's a separate district court system, an appeals system. And you're guilty until proven innocent, not innocent until proven guilty in this court. And if once it goes through the Uniform Code of Military Justice and the appeal there, it goes to the United States Supreme Court, not through the federal court system. Lower courts, federal judges are appointed and confirmed by a majority vote in the Senate. there was a common practice for more than 120 years called senatorial courtesy, in which district courts, those trial courts, where an individual senator in those district trial courts could put a blue slip in saying that they wanted to place a hold on the appointment of this person. And so they essentially gave senators veto authority over district trial courts in their state. This practice ended in 2019. Maybe it'll resume again, but it's worthy to note. It could be a question on the AP exam in that senatorial courtesy was in California. Senator Feinstein and Kamala Harris put in blue slips to stop district court judges from being appointed in their state. And the majority leader of the Senate, Mitch McConnell, put the nominations on the floor anyway. And as a result, the senatorial courtesy in the last 2 years has not been practiced. So nomination criteria, if you're putting people to the federal bench, meaning both the district courts, the appeals courts, and also thirdly, the Supreme Court, you're looking for somebody that's competent. While there is no criteria that they have to be lawyers or prior judges, that's usually what you're looking for. The party in power is looking for somebody that matches their political ideology in terms of how the Constitution should be interpreted. And during the New Deal, as you remember from AP Gov or US Gov, Franklin Delano Roosevelt tried to appoint more people to the court and pack it with people who have the same ideas. During Ronald Reagan's term of office, it became much more politicized, and we'll talk about that in just a moment. In the last 50 years, we've started considering things like race, ethnicity, gender. When we look at the court, does it have a balance to it? We've had 2 African-American justices who served on the court, 4 female justices who served on the court, and 1 Hispanic justice. And so candidates are measured up in the nomination process, as the political cartoon suggests. And so in this case, Barack Obama nominated Elena Kagan. And so you could see that the GOP is scrutinizing them. They're measuring them up. And so when they are nominated, they get a background check. And when they are nominated, the American Bar Association rates them. But the confirmation process has become politicized in the last 40 years, beginning with a very, very conservative justice, Bork, who was nominated to the court, who was against Roe v. Wade, of a woman's right to choose, which made the Democrats at the time very concerned about him sitting on the bench. And so they tried to put ads on television describing his political positions during the nomination process. It was a very close vote, but it was determined that he was not going to receive confirmation by the vote, and so he backed out. Reagan removed his name from nomination. So this confirmation process begins in the Senate Judiciary Committee, and the Judiciary Committee holds public hearings. They get the FBI background check. They call in the nominee, ask them questions about their opinions in the past, and they make a recommendation, a vote for the full Senate. And there in the full Senate, they vote on the nominee. It used to be that you had to pass a filibuster in order to get nominated in the United States Senate, meaning you needed 60 votes in order to have a vote on the nominee. But the Senate filibuster for judicial appointments has gone away since 2016. The Supreme Court is a court of appellate jurisdiction, but they do hear cases a couple times a year in which it involves two or more states, the United States against the state government, or a foreign diplomat. And so there are instances in which it becomes a trial court, the Supreme Court. There have been years that there have never been cases of original jurisdiction. And in most years, I don't know of a year that it ever exceeded 3. Last year, I don't believe there was any cases of original jurisdiction. Usually what will happen in a case involving original jurisdiction that the Supreme Court can hear, and by the way, this is in the Constitution, in Article 3 of the Constitution, about the role of the Supreme Court. In the case of original jurisdiction that applies to the Supreme Court, they often remand the case to a federal district trial court. All right, so how does the Supreme Court hear a case? Well, I'm going to go forward just one slide and tell you they hear a case because of the rule of 4. 4 justices have to agree to hear a case in order for it to get on the docket and to go through oral arguments in order for there to be a ruling on the case. So 4 out of the 9 justices have to agree. So you can see that they get a lot of petitions, 9,000, 12,000 petitions in a year that they get. They divide this up between all of their clerks that they have. The clerks review all the petitions that are had. If they see a petition that looks like it's worthy for the court to hear, they bring it to their justice. The justice who likes it will contact another justice, and they'll kind of walk door to door to try to encourage each other to hear a case. Maybe they'll even have a meeting about whether or not to hear the case, to have a vote on the rule of 4. But usually to determine the rule of 4, it's kind of made by just extemporaneous person-to-person contact between the justices that are there. So once they have determined to hear a case, they issue a writ of certiorari. A writ is a warrant. A certiorari is legal documents. And so they issue a warrant for legal documents to all the lower courts. The writ is explaining that all the lower courts need to give their documentation on this case to the Supreme Court of the United States. And in this writ, they are asking for arguments to be made from the opposing sides of the case as well. In many cases involving the United States, it is the Solicitor General who actually presents the United States case before the Supreme Court. He often is involved as a third party in cases. We'll talk about that in a moment. So what happens then after a writ is issued, or a cert, after a writ is issued, each side has to write a brief. So you have a brief from the person who petitioned, the petitioner, and you have a brief that has to be written from the respondent, the person who is on the other side. In the case of criminal cases, the petition is always going to be written by the defendant in the criminal case, because in criminal cases, there is no reason to have a petition written by the prosecution, because they get one crack at the trial, and if they lose, it ends there. But in civil cases, both sides can actually be the petitioner or respondent. Both sides have the opportunity to petition. It could be that the winner of the case doesn't think that the award was big enough, so they could petition to have the appeals court look at the case, or petition the Supreme Court to look at the case. Now, these two parties are not the only two parties who are involved in writing briefs at the Supreme Court. The Supreme Court will take, in any case, briefs from people outside the two parties. And we call those amicus curiae briefs, or more commonly called friend of the court briefs. And so if a case involves abortion, you might have Planned Parenthood write a brief. if the case involves a state and an individual, you might have the Solicitor General, that's the person who represents the president in court, write a brief on the president's opinion on the case. And so special interest groups are invited to write briefs on this case, and as is the President of the United States, the executive branch of government. The Congress at times has written their own brief from their own legal counsel, the Senate and the House of Representatives. And so then it goes to oral argument. So a date is set for the two parties to come and present their case. And it is here that the two parties have an opportunity to have 15 minutes before the court to present their case, but they really rarely are ever given 15 minutes. They're interrupted, and the Supreme Court justices sit there and ask them questions. Some justices like to ask questions. Others, like Clarence Thomas, usually always remain quiet. So how the Supreme Court works after they have heard oral arguments, they have to write an opinion of the court, which is going to establish precedent for every court across the United States. So there are two types of opinions that become the opinion of the court, the holding of the court, and that is a majority opinion where at least 5 justices agree on the opinion, or a single opinion. And here is something that's extremely interesting about our courts. We often think of the Supreme Court as being very controversial, but we only hear in the news about controversial cases. You may be surprised to learn that more than 50% of the cases, in some years as high as 60% of the cases, all 9 of the justices agree on the opinion. And so other types of opinions, well, when the majority writes an opinion, sometimes somebody wants to offer their own interpretation, even though they agree with the opinion that's been written. That's called a concurring opinion. There's nothing that becomes precedent from this concurring opinion, but somebody who writes a concurring opinion is a part of the majority. And then we have the minority opinion, or the dissenting opinion, it might be called. And that is the people who are not a part of the majority, the justices, what their opinion is. Why would they write that opinion? Largely so that it may influence future courts. For instance, in the case of Plessy versus Ferguson, which was overturned by Roe versus Wade, you may remember this from your U.S. history course. Plessy said that separate but equal facilities is equal, and then Brown versus Board of Education says no, when you separate, it's inherently unequal. That is a perfect example of a dissenting opinion being written that they pointed to when they reevaluated the issue of separate but equal. All justices believe that they should follow past precedent of letting past decisions stand. That's called stare decisis, a Latin term. Let decisions stand. And it's going to be a precedent that, while every justice follows, to the degree in which they follow kind of determines whether or not they're labeled activists or people who practice restraint. And it's often a way in which we look at their judicial philosophies as well, how they view stare decisis. We have seen this diagram once before, but before we go any further, I just wanted to point out that we often say that the legislative branch is the only branch that creates law, and that's not necessarily true. The administrative branch creates administrative law, and the judicial branch creates common case law. And when we look at law itself, there's a hierarchy to it, so that's why we often say that it's the job of the legislative branch, Congress, to create law. While you hear people say it's not the job of the executive and judicial branch to create law, because of the hierarchy of law. The most highest law in the land, obviously, is constitutional law. And then there's the law created by Congress. It needs to be in line with constitutional law. And then we have the administrative law. It must be aligned with the statutes that were written. And then we have the decisions by the Supreme Court, which must be in line with the administrative law that's written, stare decisis, the statutory law that's written, stare decisis. And when they determine that it's not following the Constitution, judicial review, they could rule these things unconstitutional, the statutory law or the executive order. They could rule it unconstitutional because they believe it doesn't follow the original hierarchy of law, the Constitution itself. So what are the factors that influence the Supreme Court? Precedent. But we have examples of, that I gave you before, where precedent was overturned. Plessy versus Ferguson was overturned by Brown v. Board. The judicial philosophy may determine a Supreme Court's decision. One way in which we look at it, I wouldn't consider it a philosophy. I'd consider it a behavior. An example of the philosophy would be strict construction. But when we look at the behavior of justices, do they practice judicial restraint? Meaning, do they follow the intent of the framers? Do they follow previous decisions of the court? Do they restrain themselves and not impose the politics of the day and their own political opinions? Or do they become active, like in the case of Brown v. Board of Education, and overturn a previous decision? Or do they become active, like in the case of Obergefell versus Hodges, making same-sex marriage constitutional? There are times that maybe the behavior of the judges feel it's a warrant not to follow stare decisis, not to defer to the executive branch, the legislative branch, the state courts, and past court decisions, and create a new decision, activating a new decision. If we go back and we look at this, often it's these two terms, judicial restraint and strict construction, are determined to be the same things by people, but they really aren't. This talks about the behavior of the decision. This talks about how the Constitution is interpreted. So we talked about strict construction, in that strict constructionists look at word for word the Constitution and try to determine the founders' intent. Well, that may be true. For instance, you can overturn Roe versus Wade, the decision on abortion, because you're a strict constructionist, and you would be saying that, hey, there's nothing in the Constitution that describes privacy. It's kind of crazy to create a penumbra of privacy. And so because it's not in the Constitution, therefore it's not protected, a woman's right to choose in the Constitution. If you're doing that, you're a strict constructionist, understandably. You can understand your judicial philosophy, but that would not be a practice of judicial restraint, because it would be overturning a previous court's decision. It would be an example of a strict constructionist practicing judicial activism. And so just because you're a loose constructionist doesn't mean you're an activist as well, in the case that was previously mentioned. Public opinion at times factors into the justice's decision. Now, Supreme Court justices serve for life. Federal court justices serve for life. And the reason is that so that they are not influenced by the politics of the day. But in some decisions, the court has to determine its own credibility. Then if something is so hot of a topic, they try at times to try to cool the political climate and come with a decision that they feel will best serve the nation, but also best serve the court for the long term. So that is our lecture on the federal court system. And I'm trying to remove my screen here. So go ahead and get started on Unit 2C. And you've got some crash course videos to watch. You've got some reading in your crash course book that you need to complete. And then we'll move on at the end of this week to Lesson 8 in our guide, in our unit plan. And we will begin to look at judicial review and the Supreme Court procedures more in depth. So goodbye, and good luck to you this week.